Let's begin with Business and Immigration Law Update. This is a proud presentation of the Khurana Law Firm, where the Chief Attorney at Law is Attorney Ramesh Khurana. This week, Attorney Kenneth Haber will question Attorney Khurana on labor investigations of LCAs in the H-1B program. Let's take a look.
Welcome. I'm Kenneth Haber, former Assistant United States Attorney, former Senior Attorney in the Office of Investigations of the Office of Inspector General of the United States Department of Health and Human Services. This is the Capitol Forum, and with us today we have Ramesh Khurana, a well-known immigration attorney. Welcome, Ramesh.
Thank you very much, Ken. I really appreciate your kind words about me.
Well, you know, you are, as far as I'm concerned, A1, top of the line immigration attorney. You know, I trust this man with my wife. In fact, I did in processing her citizenship and processing her A1 status. So,
I'm grateful to you.
Use of the product is certainly a sign that one appreciates it.
I'm really grateful to you, Ken.
Today, what we have is the topic of the Department of Labor, U.S. Department of Labor investigations concerning labor condition applications and for H-1B visas. And I'll ask you to please explain to our viewing audience what's the importance of this? What does it involve?
Well, you know, Ken, since you are a former assistant United States attorney, I knew you always like to hear anything about investigations. And that's why you are probably asking me this investigation question about the U.S. Department of Labor. Sure, I'll be very happy to answer your question, Ken. Ken, when we are talking about investigation by the Department of Labor, now I think we are talking in respect of the labor condition application. The labor condition application is the underlying document when an H-1B petition is filed. And employer would indicate on the labor condition application how much wages he is going to pay to the H-1B employee. And if he fails to pay the employee which he attested to the U.S. Department of Labor, and if he is investigated by the Wage and Hour Department, he is going to be penalized. And these penalties are very severe. These could be civil as well as criminal penalties.
Wow. An employee who comes over from overseas to work here has a lot of protection, more than our own people.
You are right. You know, there is a reason for that, because there can be an abuse of the system by the U.S. employer by bringing in foreign employees on H-1B status, because they are employees are trying to protect their H-1B status, and they are subject to be exploited. So that's why U.S. Department of Labor has promulgated these kinds of regulations, because U.S. employer is not hiring a U.S. willing and able person. In a way, he is offering that job to a foreign national. And if foreign national is not fully paid, if that becomes the incentive for the U.S. employer, that has got to be encouraged. If it is a fair game, absolutely no problem. So you pay the X amount of wages and ask them to work for X number of hours, whatever you stipulate, absolutely no problem. But if you try to abuse the system because the employee is a foreign national, U.S. Department of Labor is going to be very strict about it, and U.S. Department of Labor is going to investigate the issues.
I presume that's in order to protect the employees that are U.S. citizens and U.S. Green card holders from unfair competition by employers bringing in people who accept lesser wages.
Yes, Ken, purpose is twofold. One is, of course, what you explained, and second is to protect the wages of the foreign national as well, so that foreign national should not be underpaid.
How is the employer notified by the Department of Labor of such investigation going on?
You know, whenever a determination is made by the Department of Labor that they would like to investigate a particular employer. So they would send a letter to the employer and saying that we have chosen your company. Now, they would not indicate if the investigation has commenced because of a complaint filed by an employee. They do not disclose that why they are investigating a particular employer. They will say, we have decided to investigate you and we ask you to provide us this information. It will be a long list. Provide us your payroll records, provide us the list of all the employees who are H-1B, and tell us how much they are paid and what types of labor condition applications you have on record. So they would like to ask for all those records, and these records will be perused by the U.S. Department of Labor by their wage and hour division.
It's similar to the wage and hour, making sure that government contractors pay the wages that they've agreed to pay their employees per the government contract, I suppose.
That's right. You are 100% right. This is mandatory for the government contractors, especially when we are talking about 8A companies. Now, there is a requirement for 8A companies that if you are hiring some contractors, you have got to pay them fully as per the U.S. Department labor laws. Yes.
Well, they're trying to keep labor fair, I suppose.
Yes.
What obligations does the employer have to pay the wages that are certified in the LCA?
When the labor certification is certified by the Department of Labor, as I said, this is based on attestations which are made by the employer to the U.S. Department of Labor. He says, I will pay this employee $80,000 per year, and this employee will work full time, 40 hours per week. Okay. Now, once you have said you are going to pay this employee $80,000 a year, you have got to pay this employee $80,000 a year. You cannot ask that H-1B employee to sit on the bench and you say, I do not have any project for you, or I am still waiting for the license to be given to do this business, or you have applied for the Social Security and you cannot be paid. No, you have got to pay him. Once the employee has entered into an employment agreement and the employee is available to work, the test is the availability. If he is available to work, the employer has got to pay that employee. Otherwise, this employee is going to be in trouble.
What if the employee is not available? Say he gets sick and he's not available, and the employer has to start a project, has to carry out a project, and they put somebody else in. Do they have to get rid of that employee that they put in order to take back the H-1B visa holder once he's well?
You know, Ken, here the situation is, if the H-1B employee is unable to work because of the sickness, no other reasons, like it's not the benching or taking out of active employment or employer trying to abuse the situation, this is because of the situation which belongs to the employee. Under these kind of circumstances, there is no reason for investigation. So, employee of course is not working and there is no paid leave due to him, he cannot be paid by the employer. So, this is sure. Now, you are talking about replacing the H-1B employee, that is a business decision which the employer has to make. If he has made a commitment that a particular project has to be completed in some particular period of time, of course, he cannot wait for the employee to be fully recovered and then start working on it. So, it will depend on a case by case basis, but this is not the fault of the employer, and this is not a violation of the labor condition application, because the employee himself or herself has become unavailable to work.
So the employer wouldn't have to can the American citizen in order to take back the H-1B holder. He can continue on with the person he replaced the H-1B holder with.
Yes, that's right.
That's good.
So long as he is not violating any attestations made on the LCA, there is absolutely no problem. There is no reason why he should be penalized.
What's the time frame for the Department of Labor to complete such an investigation? Because obviously time is of the essence.
Right. It depends. There is no time limit. I have seen in my practice certain investigations have taken even more than a year. What happens is when the investigation is commenced by the Wage and Hour Department or the Department of Labor, they have gotten hold of all the documentation. Then they would like to schedule an appointment with the employer. They will come to the office, sit across the table, discuss everything. They will say, okay, employee X, do you have the labor certification certified? Yes. For which location? How much have you paid? How much did you promise to pay? And if they find there are certain gaps between what was said and what has actually been paid, then that employer can be asked to pay the back wages if there is any deficiency or shortfall. But this process is very cumbersome. Once the investigating officer has made a determination that, okay, these are the deficiencies, these are the shortcomings which have been discussed with the employer, then he has to submit the report to the attorney office. Attorney office is going to review it, whether all those arguments are legally sound or not. And depending upon how preoccupied the attorney's office is, sometime it may take 6 months. The file is not returned by the attorney office to the investigating officer and the period adds up. So it all depends.
Do they only have to repay the missing wages, or is there a penalty as well?
Both these components are there. Now they may be asked to make up for the deficient wages. If an employee has not been paid, let's say for a period of 3 months during the last 1 year, they have to pay the back wages, and then there may be civil penalties also, depending upon if this is a pattern or this is just one case. So depending upon the situation.
So there's some discretion there as to...
Yes, depending upon the case situation. If there are 10 employees and he has violated in respect of 10 employees, that means there is a pattern and they would like to check this pattern and fix this problem. Then probably the employer will be subject to heavy penalties.
Well, I'd like to thank you again for coming on the broadcast, and if there's any group or human relations department that would like further elucidation on this or any other immigration topic, I'm sure that by calling the station they can get in touch with Ramesh and set up for a seminar of their own. Thank you very much for coming
Thank you very much, Ken. I appreciate inviting me to the Capital Forum, and it has been a great pleasure spending time with you. Last but not the least, I would like to advise the audience, if you have any immigration issues, please discuss with a competent lawyer of your choice. Thank you very much for being with us.